All right, welcome in everyone to another deep dive here on the show. Today we're going to be tackling a pretty significant case, a Supreme Court case called Rimini Street, Inc. v. Orco USA, Inc.
Yeah, it's one of those cases that, you hear about these Supreme Court decisions and everything, but we're going to kind of take a deep dive into it and really figure out, what's going on, what it's all about.
And today we're going to specifically be looking at how the Supreme Court interpreted the phrase full costs within the context of the Copyright Act.
Right.
So we had oral arguments back in January 2014, January 14, 2019, where the justices really were trying to figure out what these words meant, right? What is full costs?
Right.
And we're not going to bore you with all the, the ins and outs and all that. We're just going to get right to the point, make it easily digestible, and give you the need-to-know information, right?
Right, yeah.
So let's start with a quick summary of the result in this case. So basically, the case revolved around whether the term full costs, as mentioned in the Copyright Act, includes litigation expenses that are traditionally kind of defined as taxable costs under federal law, specifically 28 U.S. Code Section 1920.
Right.
And the Supreme Court actually sided with Rimini Street on this.
They did. And, it's important to note that when we talk about costs in federal law, it's not just this, normal everyday word.
Right.
It's a very specific legal term of art.
Okay.
And it's defined in 28 U.S. Code Section 1920.
Gotcha.
And so that section lists the very specific categories that can be awarded as costs.
So it's not just any cost, it's very specific.
Exactly.
Legally defined categories of costs.
Filing fees, witness fees, things like that.
Okay. All right. So then it begs the question, why is the word full there, right?
Right. Well, that's a great question. And that's actually, what the arguments in this case kind of explored, was this historical perspective on full costs.
Okay.
And particularly, in the 1831 Original Copyright Act.
Oh, wow. Okay.
The defense argued that full at that time simply meant all of the allowable costs under what were, kind of the prevailing fee schedules at that time. And interestingly enough, sometimes those fee schedules relied on state law. So, it wasn't expanding the types of costs, but it was making sure that all of the allowable costs you're fully reimbursed.
I see. So it's kind of like saying full means like you get all of them as opposed to just like a portion of them.
Exactly.
Yeah.
So it sounds like the court was really looking for like a consistent meaning of costs over time, and they were a little leery of like modern interpretations that maybe strayed too far from out there.
From that established practice. So you mentioned 28 U.S. Code Section 1920.
Yeah.
How does that come into play with this history?
So that section and its predecessors, actually, like the fee bill of 1853, were really, presented as comprehensive lists of what costs meant in federal litigation. And so the argument was that if Congress had wanted full costs in the Copyright Act to mean something broader than that list, they would have had to say so explicitly. Their silence meant they were just talking about the established meaning.
Right. So if you think about it, right, if we're looking at this and full costs meant like any expense that you had in a lawsuit, then that would kind of create some problems with other parts of the Copyright Act.
Absolutely.
Like there's a section that allows for attorney's fees, right?
Yeah.
To be awarded as part of the costs.
Right.
So if full costs meant everything, then why would they even bother mentioning attorney's fees?
Exactly.
It'd be kind of redundant.
That's exactly the point. And even more broadly, that interpretation could make other federal statutes about awarding costs seem unnecessary. Because the American rule, the basic idea in American courts is that each side in a lawsuit pays their own, lawyers' fees and things like that.
Yeah.
To override that, Congress has to take some clear action.
So they can't just do it by accident.
Exactly.
You have to be very explicit.
Yeah.
Okay. So this word full really became a point of like contention, right? Like, did the justices even think that it added any meaning to this definition beyond the standard definition of costs?
Yeah, and that's actually one of the big questions, right? Is like this whole debate on the word full itself. And so One perspective was, well, full just means that you get all of the taxable costs,
Okay.
right? So we already know what cost means, but full just means you get all of them, not just,
Yeah.
some portion.
Like not at judge's discretion or something.
exactly.
They have to be. You get all of them.
Yeah.
All right.
But the other side, Oracle's side, was arguing that no, full means something much broader. It means all these other litigation expenses that aren't in that list that we talked about before.
So like it almost sounds like one side was saying that full modifies the list of costs, whereas the other side was saying full modifies like everything.
Exactly.
Right.
That's a great way to put it.
Yeah.
And it's also worth noting that one challenge for that broader interpretation was that despite the fact that the Copyright Act's been around for a long time, there really weren't many cases
where courts had awarded these broader costs as full costs before kind of, some more recent interpretations.
So they kind of looked at it like, well, if this is really what it meant, then wouldn't we have seen, a bunch of cases in the past
Exactly.
where this has already happened?
If that was always the understanding, you'd see that in the case law, and they didn't.
Yeah. Okay. So you mentioned Congress a couple times.
Right.
So how did the history of this law in Congress kind of come up in these arguments?
Well, the arguments also looked at the legislative history of the Copyright Act.
Okay.
Particularly, when it was revised in 1976.
Okay.
And at that time, they were thinking about this the discretionary nature of awarding costs.
Okay.
And the thinking seemed to be that Congress knew what costs meant in federal law.
Right.
So if they really wanted to expand that in the copyright context, they would said so directly.
In that new law.
Okay. So there's this one argument that kind of stands out, and they call the carnage argument.
Yeah.
What was that about?
So, that was an interesting one.
Yeah.
Basically, the concern was that if the court said that full costs, it includes every expense, it would create carnage in how we interpret laws.
Okay.
Either it would mean the word full doesn't really mean anything in other laws where they talk about costs, or it would force Congress to use much narrower language than full when they actually did want broader cost recovery.
Right.
So the court was really hesitant to do something that could, create confusion across different areas of law.
So it's all about keeping things consistent.
Exactly, yeah. Right. Keeping a consistent framework for how we read legal language across all these different laws. Yeah.
And then the last piece of this kind of puzzle was the U.S. government actually got involved in this.
That's right.
So how did that work?
So the United States filed what's called an amicus brief.
Okay.
And so for people who aren't familiar, that's basically when somebody who's interested in the case, but not an actual party, files a brief that gives the court their perspective.
Okay.
And so the U.S. government supported Rimini Street.
Right.
They argued that costs really has this settled meaning that's tied to that section we talked about, Section 1920.
Right.
And that, if Congress really wants to change that and make it broader, they know how to do it.
They have the abilities
holes
to do that.
Yeah.
Okay. So we've heard all the arguments. Let's step into the 10th chair here.
Okay.
And pretend we're on the Supreme Court and give our own kind of perspective on this whole thing.
All right. So from this 10th chair, I think the argument about sticking to the established definitions carries a lot of weight.
Okay.
Because having a consistent interpretation of what costs means across all these different federal laws really gives us clarity and predictability, both for, people who are actually involved in lawsuits and for Congress when they're writing new laws.
Right. They're not accidentally overturning it.
Exactly.
Yeah.
And I get it, the everyday meaning of full costs.
Yeah.
It might make you think of a broader scope of what you can get back.
Right.
But, given the legal context, the history, and how federal law deals with these kinds of costs, I think the narrower interpretation tied to those specific taxable costs that we talked about really is the stronger argument.
Okay.
Going beyond that would kind of create those inconsistencies and redundancies that the court was concerned about. Yeah.
So, if we really do need a broader way to recover legal expenses in these copyright cases, it's up to Congress to change the law.
Right.
To be clear about that.
They have to do it explicitly. They can't do it accidentally.
Exactly. The courts are there to interpret the law as it's written, not rewrite it. According to their own preferences.
Right. They have to work within that established legal framework.
Exactly.
So there you have it, folks. In this deep dive into Rimini Street v. Oracle, we've kind of seen how a phrase like full costs can actually lead to a pretty deep.
It gets complicated.
Pretty complex legal debates.
Seems simple on the surface, but
right. It's all rooted in legal history and how we interpret statutes and just the fundamental principles of litigation here in the U.S.
And so the big takeaway for you listening is that in the legal world, words can have these very specific meanings,
right?
That are sometimes different from their everyday use. And the Supreme Court, they really value these established definitions, and they want to understand what Congress intended when they write these laws.
Yeah,
they're not just pulling things out of thin air,
right?
This case really kind of highlights how important it is to have clear language in legislation.
Yeah,
right.
And it also leaves open the possibility for Congress to come back,
right,
and maybe address this question of cost recovery,
right,
in copyright disputes if they think a different definition is needed.
Right.
So as always, we want you to think about this. What are the implications of this decision? How might it affect future copyright cases? What does it tell us about how the Supreme Court approaches its job, interpreting these laws that Congress passes?
These are just some of the questions that this deep dive into Rimini Street v. Oracle might spark.
Yeah.
And we hope you'll continue to join us as we explore more interesting cases and legal topics on future deep dives.
Sounds good.